Welcome, everyone, and thanks for joining us for Supporting Community During Trump 2.0, Advocacy and Emergency Litigation for People with ICE Check-ins. My name is Anthony Enriquez, and I'm the Vice President of U.S. Advocacy and Litigation at RFK Human Rights. This training is a follow-up to a previous webinar that we held in December 2024 on how to use emergency litigation together with community organizing to stop deportation and detention. This training focuses specifically on litigation and organizing strategies for people with final orders of removal, who are also scheduled for ICE check-ins under orders of supervision. Though many people with orders of supervision have lived peacefully and productively in the United States as our community members for years, this group of people is now a priority for deportation under current federal policy. So standing up against mass deportations means standing up for them. This training is organized into 3 sections: before, during, and after an ICE check-in. We'll share actions that lawyers and community organizers working together can take during each of these time periods to challenge detention and imminent deportation. Now, we have a lot to cover today, and we have a limited amount of time. So to maximize that time, I'm introducing my colleagues and co-presenters. Today, we're joined by Jennifer Connor, Executive Director of Justice for Migrant Families, Flor Saldivar Silvestre, Community Engagement Coordinator of Justice for Migrant Families, Carrie Battenfield, Litigation Coordinator of Prisoners Legal Services of New York, Sarah Gilman, Director of Strategic U.S. Litigation at Robert F. Kennedy Human Rights, and Sarah Decker, Staff Attorney at Robert F. Kennedy Human Rights. Before we continue, please be aware that this training is being recorded and will be posted online to maximize access to the information presented. With that knowledge, and if you're comfortable, I invite you to write your name and affiliation in the chat if you'd like to connect with colleagues at a later time. As questions arise, please use the Q&A function on the Zoom toolbar, and we'll try to answer those either during or at the end of the presentation. We won't be able to answer any questions that are answered in the chat box, so please use that Q&A function because that's where we'll be focusing on questions. Today's training also has clear goals and clear limitations. Let's talk about the goals first. The goals of this training are teaching lawyers and advocates how to prepare for an upcoming ICE check-in, including specific legal documents to prepare and file before and after a check-in. Teaching how community-based groups, grassroots organizers, and lawyers can work in partnership to gather evidence for litigation, implement advocacy campaigns with ICE to stop deportation or detention, and prepare people and families with a plan for an ICE check-in. And finally, sharing an example of an emergency litigation after a check-in during the first Trump administration that did work to stop deportation. Now, let's also talk about the limitations of today's training. You can have the best prepared litigation and organizing strategy and still not be able to stop someone's deportation. That's because the law is not the same as justice or fairness. Not everyone's deportation will be stopped under the law as currently written. And many of the legal arguments that we're presenting today are difficult, challenged, and unsettled in courts as well. But everyone has the right to use legal tools and organizing strategies to advocate for themselves. Everyone has human rights, and it's up to us together to make those rights mean something. We do that by fighting for each other's dignity, respect, and value as human beings. So thank you for joining us today in that fight. With those goals and limitations in place, let's move forward.
Hi, everyone. I'm going to talk briefly about what to do before an ICE check-in. And to help illustrate the goals of this training, we want to present at the outset the case of KN. And just try to keep these facts in mind as we move throughout the training. So KN lived in the community of Albany for 20 years. He was subject to an order of supervision for more than 10 years. He reported to ICE, so Immigration and Customs Enforcement, for more than 10 years without any incident. During Trump 1, KN, like he had been doing for a decade, went to check in with ICE and fully expected to return home to his family, his job, and his community. But on that particular day, KN was detained by Immigration and Customs Enforcement. Neither KN's family, nor his community, nor his fellow employees anticipated that he would be detained by ICE. And then KN was very, very quickly transferred to the Buffalo Federal Detention Facility in upstate New York and was scheduled very quickly for deportation to his country of origin. During Trump 1, many people have been checking in with ICE for years, were taken when they checked in for their regularly scheduled order of supervision appointment. Neither their family nor their community had any notice or warning that ICE would detain them on the day of the check-in. But under Trump 1, detention and swift deportation at ICE check-ins was the norm and not the exception. During Trump 2, it is anticipated, and in fact has been stated by Trump 2, that people with final orders of removal will be a high priority and targeted for detention and deportation. To prepare for an ICE check-in, the following steps should be taken now.
Okay, so one of the first things that an attorney can do is determine whether or not the person has filed any applications for immigration relief in the past or has anything pending. One way to do that is obviously to ask the individual, but in the event that they're not sure or haven't retained copies, doing a FOIA for their A file, and possibly also doing a request for their immigration court file, that's the EOIR file. You'll want to make sure to do a thorough history also. So asking about any prior entries or exits from the United States, any past, if they've ever been in immigration court in the past, getting a full criminal history, possibly by doing background checks, preferably fingerprint based, since that's how most immigration background checks are run, getting the actual certificates of disposition for any convictions, considering family ties, so whether or not the individual has U.S. citizen parents, children, spouses, asking about any past victimization. And the reason for this, and I'll talk about in the next slide, is to consider whether there's any forms of relief that they might be eligible for based on past domestic violence, labor or sexual exploitation, or any other crimes that they may have been a victim of. And then finally, whether there's any fear of return to the country of origin. And some of the forms of relief certain forms of relief can only be granted by U.S. Citizenship and Immigration Services, and other forms of relief can only be granted by an immigration judge. So once the person is placed in removal proceedings. So this slide has a rundown of some of the most common forms of relief that a person might be able to apply for. And as I mentioned, the first half of these are primarily forms of relief that you can only apply for affirmatively to U.S. Citizenship and Immigration Services. So one, if the individual is married to a United States citizen or lawful permanent resident, that citizen or resident spouse can file a petition on behalf of the immigrant spouse. And that's with a I-130 petition. There's also, and why I mentioned like seeing if somebody has U.S. citizen parents, because depending on when the parents, if they naturalized, when the child was still under the age of 18, and the child was a resident at the time, they may have become a citizen just by operation of law. And might be able to apply for a certificate of citizenship. There's a number of humanitarian forms of relief. These are, again, some of the more common. The T visa is for individuals who were victims of human trafficking, either labor trafficking or sex trafficking. A U visa is is available to individuals who were victims of other types of qualifying crimes. VAWA, Relief Under the Violence Against Women Act, is for individuals who are victims of domestic violence and are married to a U.S. citizen or lawful permanent resident spouse who did not go through that the I-130 spousal petition. So the individual can self-petition for themselves if they're able to show that there was either battery or extreme cruelty. So there doesn't need to have been physical violence in the relationship. Certain kinds of emotional, financial abuse can be sufficient for that form of relief. TPS, or temporary protected status, is another form of relief, but that's specific to country, and there's very limited windows when you can apply for that. If you go to the USCIS website, look up the form I-821, it will give you a rundown of the countries that are currently eligible for temporary protective status in the windows for application. These last two forms of relief are specific to minors, to children. So there's special immigrant juvenile status. It's a type of self-petition that a child can do if they've been abused, neglected, or abandoned by a parent in the United States, and you need a family court or surrogate court order to accompany that petition. And then unaccompanied children can apply for asylum, and USCIS has exclusive jurisdiction over those cases. So even if the child is in removal proceedings, USCIS, the asylum officers will be the ones adjudicating that application. If the individual has previously been ordered removed, they have a removal order, but maybe it was never effectuated, they were never actually removed from the country, you'll want to file a motion to reopen very quickly. That's a motion to reopen the immigration court proceedings. There is generally a 90-day time limit for those. So if the person is beyond 90 days, the order of removal was issued more than 90 days ago, you're either going to have to qualify for an exception or ask the court to exercise its sua sponte authority to reopen the proceedings. You're likely going to have to show some kind of exceptional circumstances, or ask DHS to join in the motion to reopen. That also eliminates the time requirement or the time limit. At the same time, you'd also want to file an administrative stay of removal, because just filing a motion to reopen does not stay the order of removal. That'll only happen once the case is formally reopened. An administrative stay is filed directly with DHS, and there are fees for both the motion to reopen and the administrative stay. So you also want to make sure that the individual can either pay those, has the money orders ready, and that those are ready to go very quickly. Forms of immigration court relief. So if the person is actually placed in removal proceedings, there are some forms of relief that are only available in immigration court, and those are cancellation of removal. There's a form of relief called cancellation that's available to lawful permanent residents, and another form that's available to non-LPRs. But those individuals have to show that they've been here for 10 years and have a relative who would suffer exceptional and extremely unusual harm if that person were removed. And then asylum, withholding, and protection under the Convention Against Torture for individuals who have fear of persecution or fear of torture if they're returned to their country of origin.
So in addition to filing any immigration-related applications for relief, you're also going to want to consider whether the individual you're working with has any other viable civil rights actions that could be filed ahead of an ICE check-in. So for example, was the person subjected to any prior abuse by law enforcement or ICE agents? Was the person previously detained by ICE where they experienced any type of abuse like medical neglect, physical beatings, sexual abuse? If so, you should really consider filing a civil rights action, and the claims that you will file will depend on who harmed your client and where they were harmed. For example, if your client was harmed by ICE, consider claims under the Federal Tort Claims Act. If your client was harmed by private prison guards or contractors, for example, employees of the GEO Group or Core Civic, you can file state law tort claims. If your client was harmed by a state actor or in a state-operated facility like a local jail, you can file claims under Section 1983. Today, unfortunately, we don't have time to get into the details of all of these types of claims, but also just be aware of relevant statute of limitations. Typically, you only have between 1 and 2 years after the harm occurred to file a claim. And getting these claims on file before an ICE check-in could put the individual in a better negotiating position with ICE and can also help insulate a person from further abuse. And in the past, some of these cases have settled for immigration relief. Filing a civil rights action can also serve as the basis for building out a First Amendment retaliation claim. And we've seen that community groups have used these types of claims to support organizing efforts and raise awareness of ICE misconduct. Before an ICE check-in, you'll also want to determine whether the person you're working with has complied with prior ICE check-in appointments in the past, and understand what are the exact requirements imposed by ICE as part of that person's current supervision. So for example, does the person have an ankle shackle or an ankle monitor? Does the person have a GPS tracking device on their phone? How often was the person required to check in? Was it by phone or in person? You want to really understand the complete history of the person's past check-ins. And this factual preparation beforehand will help you understand ICE's legal obligations should they decide to revoke that order of supervision at the check-in, which we will discuss how to challenge later on.
So another important step to take is to identify a person who can serve as a point of contact between the attorney and the detained individual. So identifying ideally a U.S. citizen, family member, friend, or trusted community member to serve as that point of contact. If the person identified is not a United States citizen, you're going to want to make sure that they have at least some kind of legal status in the country, such as lawful permanent residence or a valid visa, and make sure that the person understands the risks of interacting with immigration officials. So if that person has any kind of past criminal history, it might not be a good idea for them to serve as a point of contact going between, such as like visiting the facility or, a detention facility, because that might put them at some kind of risk, or someone who's violated the terms of their immigration status. So just something to consider for that person's safety. And then you're also going to want to discuss with your client, the detainee, what's okay to share with that point of contact, what aspects of their case, what personal information is okay to share and what's not okay to share. It's also a good idea to start collecting as early as you can evidence of positive equities. So some positive equities can be family ties and family connections. And so having family members write letters of support, talking about the role that the individual plays in the family. Ideally, those should be signed under penalty of perjury and submitted along with a copy of some kind of state-issued photo ID that makes them so that they can be used as evidence in immigration court proceedings and will be given as much weight as possible. And submitting any supporting documentation or proof of relationship, such as birth certificates or marriage certificates. If the person has been working regularly, letters from employers talking about the work that they do, the value that they bring to the workplace, as well as any pay stubs or proof of income to kind of show the financial contribution that the person is making to their family unit. If that individual has been filing taxes, that's also really good. That's a very good positive equity that a lot of immigration judges really like to see. So if you can get copies of tax transcripts or even past filings, those are really helpful, as well as showing any past education or specific qualifications for the type of work that the person does. And then finally, any proof of community involvement, community service, connections to the community. So if they're involved with a church, having members of the church write letters of support. And again, any letters of support from friends, family, colleagues should be signed under penalty of perjury and submitted with a copy of state-issued photo ID if available. And then finally, considering whether the individual if they have any specific medical needs, psychological needs, or disabilities. So getting medical records to prove that, as well as letters from doctors explaining the medical records and breaking down more concretely what the diagnosis is and what the treatment needs are. If it's a specific treatment that might not be available in the individual's country of origin, you'd want to consider putting in some evidence of country conditions that would show that the person would not be able to get their needed medical treatment if they were deported, or even if they just won't be able to get that treatment during a prolonged detention in the facility. Letters of support, again, from family, caretakers, documenting, describing any support or any support that the family provides, or the way that it might, the detention or deportation of their loved one, the strain that it would cause on the family. And then also looking to community support. So if they're receiving any supports in their community, getting letters of support from those providers.
Okay, and so ahead of your check-in, you're going to want to put together a plan of action that maps out everything that we've just discussed, including what applications you want to file beforehand, what legal filings you'll have prepared in the event of detention. And you'll also want to work closely with community and organizing groups to coordinate for possible detention and the impact it's most likely going to have on not only that person, but on their family, loved ones, and other obligations and responsibilities that they have in the community, which we'll discuss later on. And lastly, as part of putting together your plan of action, we highly recommend that practitioners take steps now ahead of their client's scheduled check-in to prepare to go to federal court. This includes not only preparing your filings, but getting admitted to your local federal district court and registering with ECF. Note that you may need a sponsor for admission, and you may need to even appear in person for an admission ceremony. Some admissions processes can take over a month, so make sure that you time this out correctly. You could also identify any local counsel and prepare to appear pro hoc vice. You'll also want to prepare your legal filings, including any potential filings for emergency relief. We'll discuss how to prepare these later on in the program. And lastly, familiarize yourself with the relevant rules, including the federal rules of civil procedure and the local rules of the district court where you plan to practice. And Jennifer, I think we're passing to you.
Yes, I am here. So we are pivoting now to the complementary role that community organizations can play in working with these legal strategies. And part of the groundwork that has to happen for that is to get to know the people involved in a very real way, to spend time with them ahead of any of these scenarios coming up. So before you're going to even come close to walking to an ICE check-in with someone, you really want to have spent time with them, sat with them, spoken with them, and getting a sense of their goals, what their background is, and a sense of what they want to share about their legal strategy as well.
And a little bit more about what we talk, aside from preparing for the ICE check-in, there is also a family planning preparedness aspect. It's very critical for immigrant families, especially in this new presidency, that they're able to have a plan in place that can be enacted if necessary. But essentially, the first thing would be to start getting any important documentation, making sure that things such as passports, birth certificates, immigration paperwork, and even financial resources, records, as was mentioned earlier, should be carefully stored and gathered, and also easy accessible in the case of being needed. And then on the family side, there's definitely we need to assign or designated emergency contact. And then potentially there is an aspect that parents may want to consider having a standby guardianship. In the case that the adults or the parents are detained, the question is always what happens to the children, what happens to them, like who's going to pick them up in school, and that kind of details. So it's very fortunate, necessary to have that document, because if the parent is detained or deported, there is that plan in place and someone has access to those documents. More than anything, there is also a piece that folks have to be informed about their legal rights. So connecting with reputable organizations that are local and informing yourself of those rights, as well as attending them. Legally, that was mentioned before, maybe the family would want to consider legal consultations just so they can solidify what are their options. But above all, I think the essence of this would be proactive planning provides the ability for peace of mind and strengthens the ability for the family to prepare for the worst case scenario.
So in addition to having relationships with the person with themselves, hopefully you as a community organization also have relationships with other agencies and organizations, attorneys. And so checking in with those folks, what's been going on as people have been checking in at the ICE office, just generally what kind of response have people had, and getting a sense of what the climate is there, and of course, what the changing climate will be. Who are the folks who's in the leadership there, and how are they shaping the atmosphere at the ICE office. And it's especially true when you have folks who have maybe not been in compliance, who have missed some check-ins, to get a sense of what's likely to happen. Of course, you can't guarantee people an outcome when they're walking into their check-in, but you can at least be prepared with a sense of what has been happening. And phone calls are a really useful tool. So we are mostly focusing on people who do have some kind of legal support. Not everyone does. So again, especially for people who may have missed an ICE check-in, or there's issues with their address, they've moved, change of venue, things like that, where there's just some questions. It can be really helpful to call in with them ahead of time. Another thing that can come up is people end up with a check-in in their old ICE office location, and they've moved, call into both places. So, and you have to be persistent and stay on the line, and it can be, you have to try multiple times sometimes to get through. And then of course, day of, like we live in Buffalo, we can have some really bad weather that truly affects people's abilities to get around, but life things come up. So in case of extenuating circumstances, again, helping someone call in if for some reason they can't make it, it's better than not showing up. And there's been so again, working with the lawyers involved is really helpful. And for lawyers to work with your community organizations, you're going to have better outcomes if there's a coordinated support. There's other types of medical and legal support and resources that exist, and community organizations can provide linkage. So locally, we have a partnership where we can refer people as a community organization for forensic medical appointments to support their claim, for example. And another one I was thinking of is with family attorneys, like maybe someone has an immigration attorney and that person doesn't have the time, resources, or ability to do that standby guardianship piece. So you may be able to make that kind of legal referral, and thinking outside of just the traditional like immigration network, professional network. There's additional medical and legal supports you can put in place ahead of time. And you saw that long list of letters that Sarah Decker was going over, or maybe Carrie Battenfeld. So lawyers meet with people and they give them these lists. Okay, go get all of these letters. It's really hard, and people have lives. And it is a really important role for community organizations to support people in getting those letters that have been identified and getting those support pieces lined up. Something we've done is to write a kind of framework of like that they can share with their community. Hello, I am asking your support in writing a letter and helping them frame what they're asking for, where to send it, and then supporting with the translation of that letter if needed. So once people have their action steps, it's really helpful to have the community side support for it. Okay, so we are now at day of. It's the day, and you're going to walk in with someone. Every ICE office is different. This is our local office in Buffalo. And you do want to meet people early and ahead. Just reduce stress anywhere you can. Our building is unmarked. It is a luxury hotel. It's you have to walk in and speak with the general reception desk. They only speak English. So there's these layers that make it already kind of a hostile environment. Every office is different. So I do recommend get to know those layers, like, and prepare people. Walk them, verbally walk them through ahead of time, where you're headed. You're going to walk in. We then have to access a locked bank of elevators. We have to get someone to let us in. But so knowing each of those specific pieces ahead of time, it's helpful. Like anything that there's so much that's unknown that anything you can put in place that's predictable is very helpful. You go up the elevators in our case, and then you're finally at the field office, at which point I think this is pretty standard. You go through metal detectors, and enter a waiting area. The person has given their name and said I'm here for check-in with their whoever has been assigned to them. And then you're in the waiting area, wait for the name to get called, and then both of you can go back through the whatever private door into a private meeting space where you will sit and speak with the ICE official.
Okay. And it's important for people to remember that they do have rights during these check-ins. They can always request that their attorney be present with them, request interpretation in their best language, including interpretation of any documents they're handed or asked to sign. They can be accompanied by a family member or loved one if they have a specific medical condition or disability. And they can request copies of any documents that they are given by the government. And if they make those requests and the requests are denied, they may be able to argue in federal court that their constitutional right to due process was violated, or that they were denied a reasonable disability accommodation, and so that their rights in that regard were violated.
Sorry, I couldn't unmute myself. So I think going back a little bit to the accompanying part, as Jennifer mentioned, like this is the point where we made a plan, and then this is the day of, there is an appointment. And I think focusing on the aspect of accompaniment, many folks who are required to check in with ICE, with immigration, it can be a very daunting and scary experience. A lot of these check-ins, folks sometimes don't know what the intention is or what may happen at the end of the day. It can have life-altering consequences, including deportation, separation from family, just a large variety of things that can happen, all because of going to an appointment. So I think more than anything, accompaniment is more than just a kind gesture. I really want to emphasize that it's really a vital act of solidarity, of fighting for justice and human dignity. Accompaniment helps someone not only feel supported, also not feel isolated in this scenario. Often in this scenario, many folks are navigating this experience alone. And so it allows for someone who's accompanying them to bear witness and also show them that they're not alone, that they're not invisible in this situation, and that although they may not be their situation, they can understand and help them in that scenario, advocate for them. It sends a very, very strong message to the systems in place, and it's one of it of accountability. Like when someone's not watching, what are they going to be doing? Life, like in any situation or any institution, really should be reminded that interacting with community members, whether that be because of their skin color, their differences, whatever the difference may be, that people do deserve a right to be treated with dignity. And I think above all, it does prevent having that person be a witness, be an observer. It helps prevent exploitation, unfair untreatment. I think we can vividly recall our own experiences with the DMV, that when someone goes by themselves, maybe you won't get treated the same way, even as an English speaker. But usually when you have someone there to support you, it's often a little bit easier, or have someone to support you and feel that you could speak up for yourself or advocate if necessary. And I think, again, that leads into the idea that accompaniment can lead to tangible outcomes. So I think that's another big part. Like, we're not there to be problem solvers. Our main role is not for you to troubleshoot everything. Usually accompaniment is supposed to be someone who can be an observer, who can take notes and see that the person who is providing those services is adequately doing it or in a proper way. And I think I mentioned briefly that because language is a big barrier, accompaniment, the main role isn't necessary to be interpreter. That is a plus, that is helpful. But technically, like, it's a very gray area. Technically, agencies are supposed to provide interpretation in that kind of scenario, but in our experience, they more than often do not. So in that scenario, it's just kind of like weighing out the odds. Is it more beneficial for you to just be an observer and not step as an interpreter, even though that isn't your main responsibility? But often we are trying to figure out we're trying to make the best out of all the bad circumstances. And so often we do choose to interpret rather than just standing by as an observer. But everyone has their own limitations. And again, it's not the main role. The main role is not to be an interpreter, it's to be someone there to accompany, provide that support. But more than often, when that does happen, we try to check in with volunteers if they're comfortable with that. And the idea is having that plan that if someone's going in there and their plan is to ask for their passport back. That was an example of something that happened recently. Someone did want to get their passport back and was able to be accompanied by someone, but that plan was already in place. That intention had already been previously spoken about. So the day of the appointment, the person accompanying the person to the appointment was able to advocate for them and let them know, like, hey, they want their passport because they need to file some kind of document. And then successfully, because of that, they were able to check out the passport for a month. So just to go show a little bit of how accompaniment, although it may seem just like a kind act, it's more than that. It helps folks go through that process, not being isolated, and also being able to hopefully accomplish their goals.
So we're now going to return to the case of KN that I briefly touched on at the beginning of this webinar and talk about what happens if KN is detained, which he was detained when he went for his order of supervision check-in. All the things that we've been talking about in this webinar are things that should have been done before KN went to its check-in. And in an ideal world, everything would be prepared to then quickly go and file in federal court. In the matter of KN, the real story was that nothing was prepared. And so we had to work backwards very quickly to be able to get into federal court. But ideally, what should happen is that you have whatever applications for relief might be available pending. You have community support letters, you have a community action plan, you have everything ready to go. And then you have actually a draft of the papers that you're going to file with the federal district court. You also should maybe have a draft email ready to send to the United States Attorney's Office to say you're going to be filing emergent relief. And as we touched on before, you should be familiar with all the local rules in whatever court you are practicing in, because each court differs. In terms of, the legal claims arising from government conducts at the check-in, we're going to touch just very briefly on jurisdictional issues in this next portion. Jurisdiction is one of the main obstacles to getting into federal court or to have the federal court review your claims. In this webinar, we're citing to 3 provisions regarding jurisdiction, but there are others, so you should not take this as exhaustive. And the government will often raise these different jurisdictional provisions to say that the federal court does not have any jurisdiction to review.
In addition to the statutory citations that you just saw that the government might use in federal court to say this court doesn't have the power to hear this case, there was a Supreme Court case, Department of Homeland Security versus Thurisigium, that was decided in 2020. And there have been subsequent district court and circuit court cases that have further developed the law under Thurisigium. This line of cases is also going to be relevant to any arguments that the federal district court that you're arguing with does have jurisdiction. So in Thurisigium, the Supreme Court confirmed that Section 1252, some of those statutory cites to jurisdiction that we had on the previous slide, they confirmed that those jurisdiction stripping provisions that are mentioned in that statute are not exhaustive. and that those statutes don't strip jurisdiction for the universe of deportation claims, but instead only for a narrow class of alien challenges to discrete actions. So we really recommend before you litigate these types of cases that you read Thuricidium and any cases in your district or your circuit that reference that case, because they're going to be very important for your legal arguments. We've also posted a citation to a law review article that makes some arguments on how you might be able to work within this field of law. You could consider arguing that Thuricidium stands only for a very narrow proposition. So the case of Thuricidium was for a non-citizen who was placed in expedited removal. That means that he had recently arrived to the country. He hadn't been permitted entry, physical entry to the country except through detention, essentially. And you can argue that your client is in a different position than Thuricidium, that there's someone who's lived in the United States for many years, that they've developed ties to the community, and so therefore this case is different than Thuricidium. And essentially, you can argue that your client isn't using habeas corpus to gain entry into the United States because they have already that record of physical presence. And just be aware that Thuricidium was careful to preserve the kind of habeas review that would be at issue in the case that you're filing for someone who is challenging imminent deportation. As the court said in Thuricidium, quoting another case, because the suspension clause of the Constitution, the suspension clause which forbids suspension of the right of habeas corpus, because of that clause, some judicial intervention in deportation cases is unquestionably required by the Constitution. We can go to the next slide.
So as Anthony just mentioned, jurisdiction is an extremely complicated, and while some courts have rejected the government's attempt to stretch the narrow holdings of cases that caution against an expansive reading of the jurisdiction stripping statutes, everybody who seeks to file one of these cases really needs to, as Anthony said, read very carefully through the case law that has developed. The real issue is, whether or not you can identify a claim that is reviewable by the district court and not stripped, and the district court is not stripped of jurisdiction. Some possible claims you can consider are First Amendment retaliation claims, pending USCIS relief claims. I think the best example of the USCIS relief claims, and a good way to think about this, is if you have a client with a pending trafficking visa, one of the actual requirements for a trafficking visa is that you're physically present in the United States. And if you are deported, you are not able to proceed with the T visa. And so essentially your right to that type of particular relief would be set aside, it would no longer exist. And therefore you could argue to the federal court that it can't be that there's no review of ICE's actions to remove you while you have a pending T visa. There's also some arguments that can be made about very specific medical and mental health claims. Again, these are all very, difficult and challenging. And if you are looking to prepare a case or think about preparing a case, please reach out to us, and we would be happy to talk with you and workshop these particular cases. I'm not trying to give these very general, broad statements here, but I just really want to caution how difficult and frankly what a minefield jurisdiction is between districts, circuits, and I think it's going to be challenging as we move forward in the second Trump administration.
So as Sarah mentioned, really the core of these cases are not a challenge to a removal order itself. Because of the way that the jurisdiction stripping provisions in statute work, all of those challenges must be channeled through a petition for review. That is a direct appeal, essentially, of a final order of removal from the Board of Immigration Appeals to the relevant circuit court of appeals. That being said, what you're arguing in your cases is I'm not challenging the fact of my removal order or the legality of my removal order. I'm challenging the legality of the way that the government is trying to carry out that removal order. And in order to do that, you're going to say the government is carrying out my removal order in an unconstitutional way. So possible arguments that may exist and that could be tried include alleging that the government denied me due process by detaining me without following proper procedures that include pre-detention notice and an opportunity to respond. You could say the Fifth Amendment of the Constitution requires that I be told before I'm detained why I'm being detained. You could, if the facts are there, allege, for instance, that the government targeted me particularly for effectuation of a removal order because of my First Amendment protected speech or because of my race. And so they used race-based discrimination, both of which would be illegal under the Constitution. You could, as Sarah just mentioned, say that the government's vitiating my right to due process to either apply for or receive adjudication of relief from removal in, for instance, a case with a T visa where you have to be physically present in the United States, or with a special immigrant juvenile status where you must be physically present in order for your special immigrant juvenile status visa to be able to translate into relief from removal. And we've placed some case citations here in the slides for people to further investigate as they're starting research for their particular cases. You could also consider making statutory or regulatory claims that ICE has been effectuating your removal order in violation of statutes or regulations. For instance, you could say ICE violated the Administrative Procedures Act by redetaining me in an arbitrary or capricious manner, where, for example, there was no factual basis for a change in circumstances like a flight risk or a sudden evaluation that I'm a danger to the community after years of having checked in. And so it was arbitrary and capricious for them to subtly detain me. You could maybe say that they previously placed me on an order of supervision because travel documents were impossible to obtain for my country of origin, and they haven't shown that travel documents are now possible to obtain. You might consider, for someone with a disability, arguing that ICE violated the Rehabilitation Act by failing to provide me a reasonable accommodation for my disability, and arguing that a reasonable accommodation is community supervision instead of detention, excuse me. And then you could also pay attention to some specific regulations that, in fact, do provide for a post-deprivation of liberty requirement of notice and an opportunity to respond. So the regulations we cite here say that ICE has to tell you why they are detaining you and give you an opportunity to respond to those reasons, albeit after you've already been detained. And you could both say that they have to do that after, but also there's a constitutional right that they have to do that before that isn't explicit, but does nonetheless exist. So finally, we are just going to reference some of the documents that you could file for emergency relief. That in fact, you have to file when you're filing for emergency relief. We mentioned some of these in our previous presentation. And so if we're not going to go too in depth here, given the limited amount of time we have and questions that we'd like to make room for. But these slides just show documents that will be filed with emergency litigation, including a temporary restraining order, a preliminary injunction, an order to show cause, and a quick explanation of making sure that you're tailoring your arguments to the audience before you, whether it's a magistrate judge or an Article III district court judge. These slides will be available on the RFK Human Rights website, and the link to that will be distributed to all attendees. So that will give you more time to go over these in depth.
Sorry. And I think the community side that we were talking a little bit about is now more so implementing the actual plan. So we spoke about what should happen, what should be part of the plan. And now we're at the point where, God forbid, someone did get detained, and after ICE check-in, what happens next? And I think it's just, again, very important to revisit that immediately when that happens, revisit the plan and then refine what it was exactly. So maybe it needed to be adjusted for whatever reason. But at that point, bringing that plan out and making sure, first and foremost, that everyone who has a role in that plan is informed about what's happening. That would be the first part. All those key players need to be activated. And so that would mean that people who have been designated, whether it be like a legal advocate, a family friend, or a community group, that they all know their roles. So maybe this is also part of the family preparedness plan, like informing people of their roles and making sure they're available when it does happen. And so when the situation does go down, that those people are informed and that they know what their responsibility are. So if it is a legal advocate, that legal advocate knows that they should go visit the person who is detained. If it's a family friend who has been designated as the primary contact or someone who could potentially be a guardian, that could be another aspect. And so I think it's just another critical component of family preparedness is ensuring that the documents that were mentioned before and any other documents that may have need to be filed or prepared, now would be the time that they come out. So this could include any kind of like guardianship paperwork for the children, or maybe it's kind of immigration related documentation that already existed. And it's just preparing those documents ahead of time. It gives families a peace of mind, knowing that if something does happen, that they have those documents in place. So if one person's role of the family member is to make sure to pick up the children and ensure they have all their documentation, that's the role. And then they should be able to act upon that. And by having that paperwork available, if they do need some kind of legal assistance, they can provide that to an attorney, or again, have that easily accessible. And it's very much equally important putting plans in place for the children. So we put them in place. So if the parent or guardian, has been detained, or for some reason is in a vulnerable situation, if the plan was for the adult aunt or uncle to come and pick the child up from school, then at least the relative is aware about that. But it's very, very also essential. Not only is there actions that support people can do on, but it's also maybe even speaking to the children if it's age appropriate, letting them know that there could be a possibility for change, just so that they also feel supported by those around them. It can reduce the amount of trauma and provide a sense of stability, especially in those uncertain times. So having everyone informed of their roles, giving them their action items, communication is key, making sure their children are involved if they're of age appropriate, or what are their roles in the situation. And supporting these goals, I think we mentioned these could all be considered individual goals, but at the end of the day, any action that is taken in the plan should fit into somewhere about the goals, or focusing on the action items that the family wishes to do. So if their goal is to keep the family united, whatever that may be for them, it's again just acting on the family's goals. If their goal is to potentially have everyone stay in the US, then again, what is their goal that we're trying to do here? How do we connect the peoples in the support system to be able to advocate for that goal while they're also still being detained? So in conclusion, having a plan in place that can be acted upon by the network, and then always keeping that goal in mind of that detained member. What do they want? What is their intention with all of this? Because family preparedness is not just about surviving, it's about actively taking steps to protect your family and their future. Jennifer, I think you're muted.
Sorry. Again, keeping the goals in mind of the person and keeping the legal strategy in mind. Community organizations can now come in with either public-facing advocacy or internal advocacy, depending on what is more fitting to the situation. And that is different for each person's situation. So in the case study we saw, KN that more public gathering of community support, community ties, showing the whole person and how important they were to the community was really important. There's been other situations we've seen with a more vulnerable person where the family said, no, this person is vulnerable in some other ways. And the attorney also said, no, the public media strategy is not going to help in this situation. We need to really focus on internal advocacy. And so, yeah, and so that's, I don't know. So there has to be a process of discernment about which way you're going to go. And then work with your local organization on that too, because if you're going public, you don't want to be like one of 2 people outside of the detention center. You want to be one of 50, maybe in the downtown city, because also you got to know the landscape for that public facing part too.
And I think what Jennifer was beginning to touch upon is like, again, now that we're in the worst case scenario that someone is detained, and then what can they do now? So not only is it preparing for their family that is not detained, that it's not within their grasp or reach, but also now that they're in detention, what can be done for that individual? I think it's very crucial to have a clear understanding of where someone may be taken. I think that's the first step. So if someone is detained, what does that look like? There are detention centers all over the US. So it's just figuring out regionally where are folks most likely sent if someone who is detained locally, whether that be by a different kind of authority. So again, just knowing that the detention facility can be chosen at random, but I mean, not at random, but can be changed or might be transferred around. Again, we don't know, but figuring out what is the background, where are they going to be located is a big piece. And then similarly, now that you know where they're going to be detained, then you know within which region. So again, if someone's coming from the southern border and for some reason ended up sent to Batavia, New York, that's closer to Buffalo, that person may not be from the state of New York, so they may not have any familiarity. But once they reach out here, Justice for Migrant Families, for example, is an organization that supports people who are detained in Batavia. They provide some guidance on different levels and resources, legal support and advocacy for both people who are in detention and not in detention. So having that access to connect with organizations locally, such as JFMF, or regionally, what that may be in every other state. But that allows folks to be able to seek resources while they're detained, but also seeking information and connecting to legal service providers if available. That are usually probably the 2 key pieces. We do have a website, and our website kind of delineates what services we provide, what hotline we have available, when people can call. So having, again, those resources available to people. But if folks are not local to Batavia, not local to New York, where can they find that support? Where can they find that local organization? There are many resources online. For example, freedomsforimmigrants.org. It's incredibly helpful. They offer a directory of detention facilities, so you can figure out, locally, what does that look like? How many are in your neighborhood or in your state? As well as it links you to local organizations that operate nearby. Again, making it easier to connect with the right support in your area. And then lastly, one crucial reminder is that if you do know someone who is detained, it's essential for them to not sign anything until they speak to a lawyer. So a lot of times people believe that because, they sign a document, they might be entitled to a bond hearing. And it could be true. We just don't know that. They may not be able to understand the documents because of the language barrier, or because someone has not, a lawyer has not spoken with them or consulted with them. So again, many people could be coerced into signing documents, and that could affect negatively their case. So it's very critical if legal experts and service providers are able to meet with folks who are detained, as well as get some kind of consultation. But again, I think the key piece is to let folks know who are detained that they shouldn't sign anything unless they speak to a lawyer. And again, if they know where they can turn to for help and stay informed about their legal rights, that would be a very key piece about providing that support and ensuring that the best possible outcome is open up to them, especially since they're facing deportation.
So thank you, everybody, for joining us. We know we're right at 2 o'clock, so we're at the hour-long mark, and we've made an effort to answer questions as they've appeared in the Q&A box. But if you do have any questions that are still remaining, feel free to enter them now. Someone's asking if the slides are copyrighted. That's the slides will be distributed to attendees and will be posted on the RFK Human Rights website, so they will be available publicly. Just keeping respectful of everybody's time. If there are no further questions, I'll close out by saying thank you for joining us for today's training. Today, we learned concrete actions that community organizers and lawyers working together can take before, during, and after ICE check-ins to challenge detention and imminent deportation. For those who are planning and preparing legal strategies for clients with ICE check-ins, including federal court filings, RFK Human Rights invites you to join us for monthly emergency litigation workshops and working groups that we will be establishing starting in the month of February. There, we will workshop cases and legal claims for people with final orders of removal that lawyers can file in federal court. Details on registering for workshops will be available on the RFK Human Rights website and will also be distributed through National Immigrants' Rights listservs. So please keep an eye out for those. We hope to see you soon, and thank you once again for joining us. And a quick reminder, please fill out our post-webinar survey. These surveys help us identify trainings that are responsive to community needs. It's because of responses on our previous training that we decided to focus on a training on people for ICE check-ins. So we want to continue to be responsive to those community needs, and we ask for your participation in the post-webinar survey. And thank you as well to our partners, Justice for Migrant Families and Prisoners Legal Services of New York.